Welcome back to The Act, where we host military veterans and talk about their disabilities and their experience with their disabilities. Yeah, that's it. Today, we welcome Mr. Kevin Hable. Oh, got it. Yeah, help him up. Come on. Are we back on? And we're back. Yeah. Mr. Hable, how are you doing today?
I hate you.
Okay, that's cool. Anyways, so what exactly are your disabilities?
I broke a leg, a torn ACL, been shot in the ankle, I'm dead in the head, can't walk.
Amazing. Anyways, so what do you do for a living, Mr. Hable?
As of right now, I'm a substitute teacher at Midwest City High School, man.
So, Mr. Hable, what are your experience with working with Midwest City High School?
It's hard, man. The elevators don't work. I gotta walk across the hallway to get to the stairs. Takes me forever to climb up the stairs, man.
Man, it sounds like, well, the ADA didn't do its job.
The ADA?
Yeah, the ADA, the American Disabilities Act of
What's that supposed to
1990.
do?
Well, basically, it is civil rights law that prohibits discrimination based on disability. But what I mean by it's not helping you in your case is that it is supposed to provide reasonable accommodations to employees with disabilities and impose accessibility requirements on a public accommodation. Anyways, what I'm saying is the elevator is not always working. So they're not following the guidelines of the ADA.
You're dang right they're not following the rest.
Anyways, so what is the reason you got your disabilities? How did you get these disabilities?
I've been in a lot of wars, man.
A lot of wars. What wars have you been in, sir?
World War I, II, and III, man.
That means he really is dead in the head. Anyways, and we're back. So, Mr. Hable. You good? Anyways, so give this man some water. Thank you. You good now, man? So, Mr. Hable, would you ever consider going to court for something like this?
I would.
You would? So why haven't you yet?
I just haven't thought about it, man.
Well, here are a couple court cases that can help you in the fight. The first court case we're going to talk about is Breakdown versus ABOT. In this court case specifically, the ADA stipulates that those with disabilities cannot discriminate against medical treatment. In order to receive protection from the ADA, ABOT was required to show that she had an impairment and that it substantially limited a major life activity on which the court sided with her claim. The next court case we're going to talk about is Sutton versus United Airlines, Inc., 1999. In this court case, the Supreme Court ruled that two women who had sued the airline for not hiring them as pilots because they did not meet vision standards could not claim discrimination under the ADA because their correctable vision impairments did not constitute a disability. The next court case we're going to be talking about is Raytheon Company versus Hernandez. In 1991, Joel Hernandez tested positive for cocaine use in drug tests administered by his employer. As a result of the incident, he was forced to resign. In 1994, he reapplied for a job from the company. His application was rejected. Hernandez claimed that the company was discriminating against him because of his drug and alcohol addiction, though at the time he reapplied, he had been sober for 2 years. In violation of the Americans with Disabilities Act of 1990, the district court sided with the company, dismissing the case before it ever went to trial. The next court case we're going to talk about is Fry versus Napoleon Community Schools. This case is a United States Supreme Court case in which the court held the Handicapped Children's Protection Act of 1986 does not command exhaustion of state-level administrative remedies codified in the Individuals with Disabilities Education Act, when the gray man of the plaintiff's lawsuit is not related to the denial of free, appropriate public education. The next court case we're going to talk about is Olmstead versus LC, 1999. This is a United States Supreme Court case regarding discrimination against people with mental disabilities. The Supreme Court held that under the Americans with Disabilities Act, individuals with mental disabilities have the right to live in a community rather than in institutions if, in the word of the opinion of the court, the state's treatment professionals have determined that the community placement is appropriate. The transfer from institutional care to a less restrictive setting is not opposed by the affected individual, and the placement can be reasonably accommodated. Taking into account the resources available to the state and the needs of others with mental disabilities, the case was brought by Atlanta Legal Aid Society, Inc. The next court case we're going to talk about is Board of Trustees of the University of Alabama versus Garrett. In this court case, the majority opinion stated that Congress, in enacting the ADA, has satisfied the requirement that it make clear its intention to abrogate state sovereign immunity and allow states to be sued for damages under the 14th Amendment. However, the majority opinion also stated that part of the ADA to lack the congruence and proportionality required when Congress exercises its enforcement power under the 14th Amendment. Under the Equal Protection Clause, discrimination against people with disabilities is analyzed by rational bias, security. If the discrimination has a rational bias, it is constitutional. In this case, the court held that Congress, like the judiciary, was required to use rational bias review of state action with its presumptions favoring constitutionality. The Supreme Court decided that the legislative record of the ADA fails to show that Congress did, in fact, identify a pattern of irrationality state discrimination in employment against the disabled.